Hello, everybody, and welcome to this Landlord Lockdown training webinar, where we are back with David Smith of JMW Solicitors. And in this webinar, David is going to be talking about subletting problems, which I know is a big problem for many landlords. So I'm really pleased that David is going to talk to us about this. Before we start, can people just confirm that they can hear? Just sort of pop in the chat box that you're able to hear us. Hopefully you can. And then we can move forward. So welcome, David.
Hi. Hopefully everyone can hear. Yes, I'm seeing lots of yeses appearing in the
Yes.
so
No, we
it
got
looks like people can hear.
Excellent. We got the messages coming through. So, David, take it away.
Take it away. You said you were going to say that. I did wonder if you would actually use the phrase "take it away." Okay.
Well, if you can think of a better one, I'll use that next time.
No, I like "take it away." Let's go with "take it away." So I'm going to talk about 10 tips. Sarah, Tessa said it had to be 10. She came up with 10 tips. So 10 tips it is.
Well, that's 2 every 5 minutes, David.
Oh, right. It's 2 every 5 minutes. That's how it works. Okay, fair enough. I think there's more than 10 tips. So the first thing I always think it's important to bear in mind when talking about these kind of situations is who the problem is actually with. Is the problem with your tenant? Is it something that they're in dispute with you with? Or is the problem with one of their subtenants? In which case, my immediate question is it actually your problem at all? And if there's a dispute between the tenant and the subtenant, the chances are that's a matter between the tenant and the subtenant and got nothing to do with you whatsoever. And the only reason you're hearing about it is the subtenant's probably complaining to you that the tenant's not doing anything. Or is the dispute with a third party? And the most common third party in these situations is the local authority. Although I suppose it could also be a freeholder or a neighbour. So these are all other possibilities, but it's usually the local authority in my experience. So I think the first question is always, who are we talking about here? And that sort of characterises, I find, the entirety of the dispute as a rule. The next thing I think is critical to say is the subletting authorised at all? I mean, there are essentially two types of subletting situation. There are either situations where the property shouldn't in fact be sublet, and someone's certainly, from my perspective, contacting me to say my tenant sublet my property. What should I do about it? And my answer to that is always terminate the tenancy and always go to court for possession, because it's not going to get better. And if you think that a tenant who's already lied to you about subletting is going to magically sort everything out and mend their ways, then you're sorely mistaken. So tenants often promise they'll fix everything, but they just never do. It's a complete lie. And you're far better off to terminate the thing ASAP, and you should just bite the bullet and get it done. If it's an authorised sublet, then the solution to 99.9% of questions is somewhere within the contract. So you need to look at the agreement that you entered into with your tenant who is subletting. So unauthorised, get rid of them, because they're liars basically, and potentially criminals as well in many cases. If it's authorised subletting, you need to look at the agreement. And the real reason you need to look at the agreement is that subletters don't really have any rights. So if I'm letting a property for the purposes of not living there myself and subletting the whole thing, then I am not protected by the Housing Act 1988. Obviously, if I'm renting a property and I have a lodger, I'm protected by the Housing Act 88, but that's not really subletting. If I'm not residing in the property at all and I've sublet the whole, then I'm not protected by the Housing Act 1988. So all the statutory protection in there goes away. And of course, one of the problems here, I'm going to come back to this, is that often subletters use really dubious contracts, and they'll actually present you with an AST that suggests they've got an assured short hold tenancy, which they clearly don't have, because the Housing Act 88 just doesn't apply. But also, they're not entitled to the protection of the Landlord and Tenant Act 1954 either, because if they've sublet the whole for all accommodation, then it falls outside the Landlord and Tenant Act 1954, and so they don't get any of the statutory protection from there at all. So in fact, subletters don't have that many statutory rights. They don't even get protected by Protection from Eviction Act in most cases. So they've got very few statutory rights, and most of their rights are in the contract. So the key thing to look at is to look at what the contract actually says about everything. If it's not, there's a flip side to this, of course, which is you sign the contract, so the contract applies to you as a landlord, assuming that most people listening to this are landlords, just as much as it does to the subletter. And if you've signed a contract that's not particularly in your interests, you're going to have some difficulty with rights as well. The end occupiers, occupiers might, of course, have statutory protection. So if you authorise the sublet, and the end occupiers are occupying individual rooms, for example, as tenants, which they probably will be, then they will be protected by the Housing Act 1988. But the subletter is not able to avail themselves of statutory protection. If the subletters, if the end occupiers were not authorised, so the subletting is not an authorised subletting, then the end occupiers do not have statutory protection, and they're not in fact protected by the Housing Act 1988 either, and in fact have very few rights at all. So rent. The most common scenario at the moment with subletting is that the rents aren't being paid. And generally speaking, of course, what subletters will say if challenged on this is, well, I'm not getting paid either, or people aren't paying me, so I'm not paying you. Now, this is usually a variable accuracy. Some people are telling the truth that people aren't paying. In some cases, I've certainly encountered people who are subletting who are saying, I'm not being paid, and actually they are being paid, but they're not being paid on all of their properties. And what they're doing is they're moving money around to deal with the most angry people first. So effectively, your money is being used to pay somebody else in order to keep their business running. Obviously, that's the way things are at the moment, but there's no particular reason why you should have to deal with that. Technically, because these people don't have any statutory rights, their only rights are set out in the contract, and the contract will allow you to forfeit the tenancy for non-payment of rent in most cases. And assuming that it does do that, you can simply forfeit the lease, and you don't need to go to court to do so. You can simply go to the property and change the locks. Now, note, when I say change the locks, I don't mean change the locks and exclude the occupiers. I mean change the locks and exclude the tenant. So if the subletting is authorised, then the occupiers are protected. They will become your tenants under the Housing Act 88, under Section 18 of the Housing Act 1988. You will inherit them, and you will then have to deal with them directly. Now, the point then, of course, is you're running a risk. Because those occupiers are now your occupiers. If they're not paying you, then you need to deal with them directly, and you've got no one else to deal with. If they are paying, if they were in fact paying, then that means that you will be able to get the money. So the subletter or the person in the middle is knocked out of the picture. You deal with the occupiers directly. They are still statutorily protected, so they are residential occupiers. The person in the middle is not a residential occupier, doesn't get statutory protection, so you can simply forfeit their lease by turning up and changing the locks. You can then sue the original tenant by way of a debt claim for money owed up to the date of forfeiture, but you'll be taking the risk in dealing with the subtenants. Now, obviously, the other option is that you leave the person in play, so you leave the intermediate tenant in play if you think the subtenants aren't in fact paying, and you don't forfeit the lease. Because obviously, the flip side of forfeiting the lease is if you forfeit their tenancy, then their liability goes away, and they're no longer able to be sued for a debt, but up until the date of forfeiture, they're liable to you. So you need to decide whether or not it's worth forfeiting and getting rid of them, but then dealing directly with the occupiers, or whether or whether or not whether in fact it's better to forfeit, end their liability, and collect money directly from the occupiers. It kind of depends on the situation. It's worth trying to contact the occupiers and find out if they're actually paying. So in principle, rent is quite easy to deal with. If it's other breaches, so if it's an unauthorized sublet, technically you can actually just go and change the locks, but in practice that's a pretty high risk thing to do. The court might decide that you had in fact authorised the sublet, in which case you would have carried out an unlawful eviction. In practice, if you just go and change the locks, the occupiers are probably going to break back in anyway, and you'll have to deal with it. Then probably you're better off to just use the courts. So if the sublet is unauthorised, you should probably just go to court. But though in theory you can actually change the locks, but I would generally recommend not doing so. But if it's an authorised sublet, then it kind of depends on the circumstances. The other common breach is a nuisance-related situation. In practice, I tend towards the position, as if I'm acting for a landlord, that landlords aren't liable for their tenants' nuisance. They're certainly not liable for nuisance caused by their tenants' subtenants. And they're not normally liable for nuisance between those subtenants because they're not liable to those subtenants at all. They have a tenant, their tenant is liable to the subtenants. So I would tend to sort of avoid getting involved in that. But ideally, your tenancy agreement should be dealing with the tenant and making sure they're managing the property properly for nuisance purposes.
David, we've had a question in about subtenants who thought that they had a valid tenancy.
And the answer to that question is no. So, if a subtenant genuinely does have, if a tenant has authority to sublet, then the subtenants are protected, both as against the tenant and as against you because of the Housing Act 88. The Protection of Eviction Act doesn't apply. If the subtenants thought they had an authorised tenancy but didn't, they don't actually have any protection at all. There have been a couple of cases on this point. But in practice, it's usually better to go to court. I don't generally recommend changing locks as against end occupiers. You can change the locks as against the tenant because the tenant's not entitled to any statutory protection because they're not occupying the property on a residential basis. They're occupying for a business, and it's a business outside a statutory protected regime.
So if you change the locks, you would have to give new keys to the occupiers and tell them not to let their landlord in again.
Yeah, basically. I mean, when I'm saying change the locks, I'm always talking about changing the locks as against your tenant, not changing the locks as against your occupier.
Mm-hmm.
Okay.
Heather has just said that council licensing seem to think that the landlord is responsible for tenants' nuisance, although I'm not sure we ought to go off on this.
Council licensing authorities think many things. They will often put in. I mean, they are empowered to put in stuff into a license around nuisance and management, but they can't turn around and make you directly liable for something that you're not liable for in civil law.
It's very rare that one person is actually liable for something another person does. I mean, employers' vicarious liability is one, but there are actually very few, aren't there, David?
Yeah, it's quite difficult to hold people liable for third-party actions. I mean, in fact, there have been some pretty extreme cases on this. The leading case is actually a Scottish case where I think it was Glasgow City Council. One of their tenants complained about another tenant. They actually told the tenant, their officers went round, told the tenant who'd complained about him, and the guy then went round and knifed the guy and killed him later the same day. And they were held not to be liable, even though their behaviour was beyond stupid. They were held not to be liable. So it's really hard to hold landlords liable. I mean, there's been a more recent interaction with this where a local authority did have some liability for nuisance, but generally speaking, it has to be a sin of commission. You have to encourage or cause or extend the nuisance, as opposed to simply doing nothing about it. But the general response is if you then sort of take on evicting the tenant in a reasonable manner, then your liability is pretty low. The next question is repairs. Obviously, Section 11 of the Landlord and Tenant Act doesn't wholly apply in these situations because it's not a Section 11 tenancy. So you need to look at in practice, most tenancy agreements will just incorporate Section 11 anyway. But who is liable for damage to the property? Who is liable for repairs? So who's liable for all of the damage and repairs? Um, uh, uh, the tenancy agreement should tell you that, but you need to read it carefully. I often uh, uh, find situations where the damage or repair liability is limited. So again, this is a real problem with the contract itself, and I'll come back to this in a minute. And then many contracts will allow you to serve notice requiring repair, and if it's not then done, do it yourself. So one option would be to simply serve notice demanding repairs are carried out, do the repairs yourself, and then bill the tenant for the cost. That's an option available to you. And in some cases, I think landlords should be more robust about doing that, because at the end of the day, it's their property that's being trashed, and ultimately that means that their underlying value of their property is being undermined.
We've had some questions in, David, but I think perhaps if we finish the presentation first and then I ask them afterwards.
Sure, no problem. So I've talked about contracts, governance. A lot of sublet agreements are really bad. I see lots and lots that are just ASTs with bits hacked around and crossed out. A common tactic of dubious subletters is to remove the forfeiture clause. If you're signing a sublet agreement, you should always get a check for the forfeiture clause. You need to make sure it's there, because if there's no forfeiture clause and the tenant doesn't pay the rent, you can't actually evict them during the fixed term of the tenancy. So a forfeiture clause is critical to a tenancy agreement, particularly where there's a sublet going on, and you need to look at the agreement you've been provided. I see so many situations with dubious subletting where the landlord signed this agreement that's just totally awful and really, really undermines their position.
Perhaps this would be a good moment just to say that we do have on landlord law a training course on rent-to-rent situations, which you mostly did, didn't you, David? It was last November. We ran an event, and the recordings are available for sale as a training course. And there is the option to buy a rent-to-rent agreement that has been drafted by David, and there is also you can also book through the course an advice call with David about generally anything that you want to about rent to rent. So, if you've got a difficult situation right now, you can always, and you want to talk it over further, you can always book one of our telephone advice calls. Or if you want to know more about rent to rent, you can get this training course, which is it's an entire day's course, so there's a lot there.
Yeah, there's quite a bit in there, and then also the agreement's pretty comprehensive, but it's reasonably balanced in respect of landlord and tenant rights. It's not particularly one way or the other, but a lot of the contracts I see are hugely biased against the owner, and they will include things like no forfeiture clause. I've seen lots of ones where repairs are thrown back on the owner, where the tenant's liability for damage is limited to really low levels. It's quite common to have clauses in that says, oh, at the end of the tenancy, if we can't get the sub-occupiers out, we can either hand it back to you with them in place, or we're allowed to just extend the tenancy for random periods of time, sometimes for a complete new year and things like that, at our whim and will. So it's really worth looking at these things. There are lots, and it's very common to see sublet agreements that are allowed to run on or be extended, mostly at the tenant's option. And landlords just sign this stuff without reading it. So it's really important that you look at what you're signing. Repairs and maintenance, who's responsible not just for the repairing, but also the maintenance of the property. In any tenancy, there's generally a degree of maintenance that's involved. Subletting often requires more maintenance because often the end occupiers are either transient or not very good. So you need to be careful about that. And you need to think about licensing. Who's responsible for obtaining any property license? selective license and complying with the terms of that license. So local authority notices. Um, um, so who's supposed to get the license? I mean, ultimately, if you're a landlord and you're letting a property to a subletter who then fills it up and turns it into an HMO, you're still liable. You're still supposed to have a license, and you can't turn around and say, "Oh, I thought they would have to get the license." You need to clarify it in the document, in the agreement, and of course, you need to chase it up. You need to make sure they've actually applied for the license they're supposed to be getting. So, as a landlord, you're entirely liable for any failure to obtain a license. The upper tribunal has held you're also directly liable to the individual occupiers who can claim rent repayment orders. So if you sublet or you let to somebody who then sublets, and the property is supposed to be licensed and it's not, then the tenants can claim up to 12 months rent back from you, their rent from you, not the intermediate rents. And you're also liable under the Housing Health and Safety Rating System if the local authority turns up and serves a notice. So you need to think about all these issues and clarify them in the terms of the agreement that you're entering into. The other thing is, who are you dealing with? I can't believe that some people regularly sign, I've seen so many sublet agreements signed with companies that have been in existence for months, literally months, or even days. So who are these people? And sometimes I've seen a number of cases where people signed an agreement with a company who was subletting. That company basically declared itself bankrupt and went insolvent to avoid paying rents they hadn't paid, but then carried on letting the same properties, apparently, to the same people from the same people under a totally different company name, and thought they could just transfer the tenancies from one company to another, which they just can't do. So sometimes people will just change their company around, and a new company will spring up with exactly the same directors and exactly the same registered office doing exactly the same work, and usually with practically the same name, in order to avoid liability. But the lease doesn't transfer from one company to another. So if your subletter declares themselves insolvent, then then in practice they're terminating the tenancy, and you should have a forfeiture clause that will allow you to terminate it. And they certainly can't assign that tenancy without your consent to somebody else unless the agreement allows them to, and you should make sure it doesn't. The other thing you need to think about is solvency. How are you actually going to ensure you will be paid? If you're dealing with a company that's been in existence, a limited liability company that's been in existence for a couple of months, and all it does is subletting, then essentially it has no assets. What are you going to sue them for? They've got no money. So how are you going to ensure you actually get your money? And these things tend to go wrong because money doesn't come in. So you should be looking for personal guarantees from individual directors, and people often don't. I'm kind of often surprised that people don't. And then the last thing, I don't know if I put local authority this, but what I actually meant is just what I should have said is think about the deal. Think about the deal you're being offered. How are they making money on this deal? And can they make money on this deal? I see lots and lots of subletting agreements where it's patently obvious that the only way the subletter can make money is either by screwing the landlord and not paying them, or by simply not doing things that they're supposed to do, like getting property licenses and repairing the property. So is the deal you're being offered too good to be true? If someone's turning around to you and saying, I'll sublet the property and pay you exactly the same rent as you would have got on the open market, but you have the additional benefit that I'm going to manage the property so you don't have to pay agency fees, then how are they making money? Yeah. So if anyone's watched, I was watching the film The Big Short recently and it was about bond trading. And this guy says, we'll do a deal with you, but we want to know how you're screwing us. So the first question you should be asking these people is, how are you making money? How are you screwing me in order to make your money out of this? And then the next point about this in the same take is, how do you reference these companies? What is your basis for trust in them? So what have you done to make sure these people are actually who they say they are and are worth dealing with? And a lot of people just don't seem to do that. There's my contact details, and I think there were some questions that popped up.
Yes, I'll also say, pursuant to contact, we also have a telephone advice service on landlord law, and you can instruct JMW solicitors to give some telephone advice. So that's another option for you. A lady called Vera has said that she's dealing with an illegal sublet. The subtenants were evicted by the police. Agent believes I can't change the locks without going through the courts. As the subtenants were running a vice ring, I was not prepared to take the chance of them coming back, so I had the lock changed anyway against the agent's advice.
Yeah, I think Vera's right and the agent's wrong.
Yeah, I have to say I think my sympathies are with Vera. Tracy asked, what notice do you serve on occupiers, particularly where the tenants are not served how to rent, gas safe, etc. So Section 21 is likely to be invalid.
That's a bit of a complicated question.
Yeah.
And the answer is it depends. One, was your sublet authorised? If the sublet was authorised and they're renting on Housing Act 88 tenancies, then if you throw out the intermediate and are left with the subtenants, it's a problem. If they don't have gas safeties and haven't had the deposit protected, then you're going to end up in the hole for that. And that's why you should have drawn up a proper agreement with the people and made sure they were doing it properly. If they're not authorised to sublet, those people don't have Housing Act 88 tenancies.
Gary asks, if the tenant is subletting without permission, would this affect their deposit?
Well, if the tenant's subletting without permission, then the end occupiers don't have Housing Act 88 tenancies, so it won't matter.
Jackie,
obviously, and they won't have a Housing Act 88 tenancy with you either, so the deposit doesn't need to be protected anyway.
So Jackie asks, how does David recommend that the end occupier protects themselves for possible illegal subletting? They might not know that their landlord is an intermediate landlord. So, I mean, this is really advising prospective tenants who may also be watching the recording of this.
Yeah, I mean, life is cruel on this one, is the short answer. There isn't an easy way. I mean, the only way to do it, frankly, is to pay your £3 and go to the land registry and go and find out who owns the property.
But I mean, if the person isn't listed there, it doesn't necessarily mean that they haven't got authority to let.
No, but it puts you on notice to ask the question.
Yeah.
But it's a problem. I agree. It's very difficult for tenants to protect themselves in this circumstance. I mean, one, I would make sure that you would need to make sure that your deposit's being protected, and you need to find out who it is that you're renting from, and ask them to confirm that they own the property or look it up.
The next question is about HMO licenses, which you've dealt with. And then Carol says, I suspect my tenant is illegally subletting. The NRLA told me I have to prove it first, then serve a tenant with the Section 21. You're indicated that the landlord has more rights.
No, I mean, if you don't know that they're subletting, you can't just go and change the logs. You have to prove the case. So if you've got evidence of them subletting, you should serve a Section 8 notice and make the case. If you serve a Section 21, you don't have to prove anything. So if you can serve a Section 21 notice, serve a Section 21 notice and remove them from the property. End of discussion.
The best answer to this, Carol, is to take advice from a solicitor who is experienced in this area of work. David says, if the forfeiture clause says the landlord has to get a court order and bailiffs to enforce against the rent-to-rent company, would this be challengeable?
No. And this is one of the problems, and this is where landlords fall down. They think that, for example, they can rely on unfair terms legislation, but they can't. Unfair terms legislation doesn't protect somebody who's supplying the service. So if you've signed a contract presented to you to supply a service to somebody, and it's a bad contract, then you're bound by its terms. You can't rely on unfair terms legislation because it's not unfair to you.
And the moral of this story, folks, is that you should never sign any document like this without getting proper legal advice on it.
That would help, yes.
Vera says the tenant has never moved in and sublet the flat to prostitutes. After they were thrown up by the police, the rent stopped. Do I have to serve notice on the tenant if I want to relet the flat, which is currently empty?
No.
Okay. Karen says she works for a housing association. We've only got a minute, so we offer rent.
The short answer there is that that's a totally different situation, because that's surely the housing association would pursue a criminal prosecution in that situation, and you'll need to have evidence. And I can't really answer that question without knowing more about the situation.
Okay. We've had another questioner who's pointed out that COVID makes it difficult for the tenant to evict the occupier without giving the 6 months notice. And this is a general problem at the moment because the courts are clogged up and the notice periods are extended and it's very difficult to get possession through the courts.
Yeah, that is absolutely true.
But there's not much David and I could do about that.
Not much I can say about that. That is what it is. I mean,
yeah.
I mean, the reality is COVID has essentially made a lot of rent-to-rent state positions untenable, and this was why it was always a very difficult business model. It's a high-risk business model, and that means it's high risk for landlords as well. It's an arbitrage-based business model. All arbitrage-based business models, whether it's share arbitrage, gold trading, whatever you want to get involved with, shorting stocks on the stock market. If you want to look at US game station stuff, it's high risk trading. And if you want to get involved in high risk trading, then there are real possibilities that the market will turn against you, and that's where we are.
Yep. Of course, if you're watching this webinar in 3 years from the time of recording, it may be different in the courts. But,
absolutely, everything will be fine.
But at the moment, it is a problem. Now we've reached the hour, so our allotted time is up. So I'm sorry for the people whose questions we haven't answered, but we only had half an hour. So we can't really take it any further now. If you do want to have any advice on your issue, as I said, we have a telephone advice service. I'll put a link to it under the recording. And there is our rent-to-rent training course, which is very useful if you're thinking of rent-to-rent. So it remains for me to say thank you very much, David, as usual, for coming along and delivering a brilliant webinar. And I can see we're having thanks from the delegates coming along there.
Thank you very much.
I will close down now, and we will be back again. Well, you and I will be back again in a couple of weeks, and we've got another webinar next week, which I think is on HMOs. So you should be able to sign up for that on the redirect after I close down the webinar. So thank you very much.